The Information Regulator of South Africa has filed an application to appeal a Pretoria High Court ruling that allows the Department of Basic Education to publish matric results in newspapers using examination numbers.
The regulator has approached the Supreme Court of Appeal after the High Court dismissed its argument on 12 December 2025 that such publication could set a dangerous precedent for the handling of personal information under the Protection of Personal Information Act. We are joined now by education analyst Hendrick Makaneta to discuss the matter. Hendrick, thank you very much for joining us. Now, you've described previously the Information Regulator's appeal to the Supreme Court of Appeal as a step towards finding clarity. Why is a definitive ruling from the SCA better for the education sector?
Nompumelelo, the step that has been taken by the Information Regulator is in line with the laws of the country. Any party that is unhappy with the ruling of the lower courts can always approach the higher courts, to seek more clarity on a ruling. And I think that this is exactly what the Information Regulator has done. But be that as it may, I think that, for the general well-being of all our learners, we need a certain degree of clarity. And I think that the Supreme Court of Appeal is better placed, to step in order to review the decisions that have been taken by the Gauteng High Court.
Many parents feel this legal battle is really a necessary drama, particularly because this is a time when they're supposed to be celebrating with their children. How do you explain to a worried parent why this legal drama is actually good in the long term?
I think that, you will recall that the Information Regulator, as the custodian of the POPIA, the Protection of Personal Information Act, has got a duty to ensure that South Africans are protected, where their information has to be given out in the public. And I know that many parents, of course, feel very happy. And over the years, it has always been done where, people buy newspapers in order to get the results of their children. But in the long run, I think that it is all about the rule of law and the supremacy of the Constitution. I think that the case at the SCA will be able to give a better test, in as far as the rule of law and the supremacy of the Constitution is concerned. It will provide clarity on whether really the personal information of learners is being violated or whether public interest should be given a priority. Remember, even the Bill of Rights, Section 36, does indicate that no right is, the rights that are there in the Constitution are not necessarily absolute rights.
Look, in your view, does the public nature of newspaper results, even with just an exam number, contribute to the stigma of failure for those who don't see their numbers listed? Nompumelelo,
in the past, when names were used, when names and surnames were used, there has been a lot of campaign coming from, different activists across the terrain of education to say that it actually brings anxiety to learners who have failed. And that is why, at some point, a decision was taken by the Department of Basic Education to rather use the student numbers or the so-called exam numbers instead of the names and the surnames. So currently, most people would appear to be happy, the fact that we are no longer using the names and the surnames. But, the Information Regulator, as I've already indicated, has got a duty to ensure that the POPIA is clarified properly so that, it can really send a precedence also for the future. I think that they've got a right to do that, and we should really respect their decision to seek alternative engagement with the SCA so that they can be able to clarify this issue once and for all, because it will impact future generations for many years to come.
Hendrick, part of the argument that has been made around the POPIA Act is that the High Court called the regulator's concerns fanciful, arguing that an exam number really isn't personal data. As an analyst, do you believe that an exam number is private enough?
Nompumelelo, an exam number, just like a student number at the university, under POPIA is actually defined as personal information, because each and every student or each and every learner has got a unique exam number that defines themselves, just like the name or the ID number in your ID. So, in my view, and in terms of the definitions that I've read in terms of POPIA, exam number is also personal information, and it should be respected as such. But of course, the arguments that have been coming forward from those opposed to the information regulator were that, not everyone may know, or people may not really know who does this exam number belong to. Hence, the child may not be prejudiced, even if their exam number is allocated or it is printed in a newspaper. Something that, of course, makes sense, except for those who are closer to the learners. I mean, learners who are in the same class, obviously, they may have an idea about the exam number that belongs to their friends and so on, because they are also given a space to sit in that particular order, and usually using the order of their exam numbers. So those who are in the same school may actually have an idea who has actually passed and who has not passed. But those who are far away from the learner may not have any idea who the exam number belongs to.
Well, that's interesting, Hendrick, that you mention the other pupils that are studying with these matriculants, that they'll have an indication of the student numbers. Do you think that the finality of this court challenge will affect other spheres of recognition in the schooling system, such as prize givings, for instance, or sports awards?
I think that it can have an impact in as far as, where consent is not given. Remember, in this case, learners normally sign a pledge, and South African learners have not given anybody, or their parents rather, the parents of South African learners have not given anyone consent, to publish. So the issue was the issue of public interest. So I think that in future, when there are prize giving ceremonies, education institutions will have to seek permission should the information regulator win in this case. They will have to sign some forms wherein they give permission to say, yes, you can publish the name of my child, or you can go ahead. But of course, that should actually be balanced with a public interest. I mean, if you look at so many sectors of society, there are many things, even in sporting codes, which are in the interest of the public, and you can't really contest in terms of POPIA there.
That will be interesting to see how academic awards, for instance, are being given at various valedictory ceremonies throughout schools. But you've noted that newspapers are important for families with poor internet access, for instance. If the SCA eventually bans newspaper publications, what is Plan B then for learners in remote areas?
It will be a sad day, of course, if the courts ban the publishing of this information. Because remember, South Africans generally, they get into a particular mood of excitement, especially when the results are published. And even someone who's a bit far away from home, an uncle or a mother, can always, access, the results from a bit far. But if that is to be stopped, of course, we will have no option but to agree with the rule of law, and of course, what the courts shall have said. but it will really, have a negative impact in the mood of society, because it will never ever be the same again. Remember, this is a tradition that has been practiced for many years. Even during that time when names and surnames were published, every year there's a hype. People feel so excited, parents along with learners everywhere in the country. It's not something that can be taken lightly. And of course, we do hope that the courts can be able to take all of these factors into consideration as and when they make a ruling between this case, which was brought by the information regulator against the Department of Basic Education.
Hendrick, as we wrap up, what's your message to the class of 2025?
We sent a message of hope and goodwill to all our learners who sat for the exams, the National Senior Certificate exams. But at the same time, we note that in most cases, not all of the learners may be able to, to acquire the same, qualifications or the same marks. Some may get their access to bachelor's degrees and so on, whereas others can go into certificates. And those who don't make it as well, we're saying it is not the end of the road. There's still a chance. It's a learning curve. They can always go back and improve on where they have not been able to make it. But generally, we want to wish all of them well as they prosecute this difficult struggle to create a better future for themselves.
Hendrick, thank you very much for your time. That was education analyst Hendrick Makaneta.